Ladies and gentlemen, hit subscribe to this channel right now. I wanted to start after the Super Bowl, but it's tied 19-19 Niners and Chiefs. I'll give you the update as soon as I see it from my cell phone. Hit subscribe. You'll hear John Roberts right now. To read my writing in The Hill, The Huffington Post, Salon, The Jerusalem Post, The Federalist, other publications, go to hagoodman.com. To my super chat, Paul Bartlett, thank you so very much. I cannot thank you enough. Feel free, ladies and gentlemen, to give a super chat during the arguments that you'll hear within the Supreme Court. You'll also hear the great and very, very knowledgeable and esteemed Jonathan Turley, constitutional scholar. Hit subscribe right now.
There was a congressional action to permit Confederate officers or people who supported the Confederacy to hold office before the 14th Amendment, correct? So there must have been a thought that there was a pre-existing disqualification.
That's absolutely right. There were a flood of amnesty requests even before Section 3 went into effect because everybody understood at the time that those people would be disqualified the moment that Section 3 was enacted forever unless they received amnesty.
Counselor, what do you do with what would seem to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot. And it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually what we would be deciding whether there was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th. Since Reconstruction. Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question, which is other states may have different views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong. And maybe they thought it was right. And we'd have to develop rules for what constitutes an insurrection.
Yes, Your Honor, just like this court interprets other constitutional provisions, this court can make clear that an insurrection against the Constitution is something extraordinary. And in particular, it really requires a concerted group effort to resist through violence, not some ordinary application of state or federal law, but the functions mandated by the Constitution.
On your point,
It certainly was not a concerted effort to overthrow anything. The Federal Bureau of Investigation found no evidence that Trump or anyone else engaged in any rebellion. Furthermore, people were let into the building peacefully. People were acquitted for being let into the building. There was no organized effort, and Trump verbatim told people to remain peaceful. CR, thank you for becoming a member. Thank you. And Paul Bartlett, and to my super chat, thank you. So, you look, ladies and gentlemen, and John Roberts, you just heard him, and what he's trying to do is get the Colorado lawyer to admit that Colorado has an opinion on what constitutes a rebellion. Trump was not convicted. Therefore, you can't simply accuse him of having committed some kind of heinous crime when he hasn't been convicted and when other states can interpret that day in January differently, just like other states have already interpreted that day differently. And so you have no evidence. See, the Colorado lawyer is actually assuming that the Supreme Court of the United States looks at January in the same way that he does and that liberal Democrats do and that the Supreme Court of Colorado viewed that day. But that's not the case. This isn't. You cannot go to the Supreme Court and say, well, we're not deciding a federal presidential contest. You are. We're just banning him and and setting a precedent for other states to ban him. But it's the U.S. Supreme Court that will be the final say in all of this. The only reason the Supreme Court is looking at this is because Colorado took the unprecedented step of banning a candidate and disenfranchising, like Kavanaugh stated, 70 to 80 million Americans. CR, thank you for gifting a membership. Greatly appreciated. Thank you. So that's the issue here. That's what's the Supreme Court and Chief Justice, as Chief Justice, he's going to lead this discussion. And you have Justice Jackson, Justice Kagan, and Justice Sotomayor all in favor, all agreeing with the 6 conservatives on the Supreme Court on this issue. They might not like Trump. They might think that Trump engaged in behavior that was, not presidential, but they do agree that the Supreme Court cannot allow one state, whether it's Colorado or any other state, to ruin the entire presidential contest. Let's listen to this again. Actually, let's go. Let's see here. So 2219, sorry. Okay. Let's go ahead and I'll give you another update in a couple of minutes. But let's listen to Justice Roberts again.
And pardon somebody for a criminal conviction doesn't make that conviction somehow contingent. And I would note that if President Trump were appointed to an office today, if he were appointed as a state judge, he could not hold that office, which shows that the disability exists now. And the fact that Congress has a power to remove the disability doesn't negate the present qualification, nor does it implicitly bestow on President Trump a constitutional right to run for offices that he cannot hold in violation of state law and state procedure under Article 2.
In fact, there was a congressional action to permit Confederate officers or people who supported the Confederacy to hold office before the 14th Amendment, correct? So there must have been a thought that there was. And a pre-existing disqualification.
That's absolutely right. There were a flood of amnesty requests even before Section 3 went into effect because everybody understood at the time that those people would be disqualified the moment that Section 3 was enacted forever unless they received amnesty.
Counselor, what do you do with what would seem to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot. And it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually what we would be deciding whether it was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th since Reconstruction.
He hasn't been convicted. So we could, what you see on that day in January is a terrible, terrible day. We also saw from Tucker Carlson's footage on Fox News people being let into the building. This is also what we saw. This is also what we saw. If you focus and deceptively edit videos, Trump used the word go peacefully. Respect law enforcement. He wasn't trying to overthrow the country or engage in a rebellion. Democrats saw a day that unfortunately was replayed every single day that summer, and I agree with why people peacefully demonstrated that summer. We had billions in property damage. Late May of 2020, the President of the United States of America had to seek shelter because left-leaning demonstrators got too close to the White House. And so, was that not a rebellion? Billions in property damage, 19 to 20 lives lost, I believe, according to Wikipedia. Was that not rebellion? Was there not a rebellion every day that summer by people who were not peaceful? And I support why people peacefully demonstrated. Was that not a rebellion? And so when he says, well, extraordinary measures for extraordinary times, we've never seen this. Yeah, we've never seen a president be accused of committing a rebellion while people were peacefully let into a building on one side of the building, and video cameras deceptively edit only the chaos and mayhem and leave out most of the people being let in by law enforcement, and a couple of them already having been acquitted. Not one person there knew or had any plan to overthrow the United States government and create some kind of new government. Not Trump, not anyone, even people who committed crimes that shouldn't have taken place. And an unarmed woman, a supporter of Trump, lost her life, as did other supporters of Trump and a law enforcement official after. Nicholas, thank you again. Nicholas, thank you so much. So, you have a situation, ladies and gentlemen, where Trump was not convicted, yet he's being kicked off of a ballot, and the lawyers are assuming that he committed a crime without him having been convicted. Therefore, the Supreme Court should side with the opinion of the Colorado State Supreme Court without Trump having ever been convicted of a crime, and people already having been acquitted because there were most of the people actually allowed into the building.
Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question, which is other states may have different views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong. And maybe they thought it was right. And we'd have to develop rules for what constitutes an insurrection.
Yes, Your Honor, just like this court interprets other constitutional provisions, this court can make clear that an insurrection against the Constitution is something extraordinary. And in particular, it really requires a concerted group effort to resist through violence, not some ordinary application of state or federal law, but the functions mandated by the Constitution.
On your point that it's been dormant for 100
How is it a concerted group effort, an organized effort through force, when the Federal Bureau of Investigation found no evidence that Trump or allies engaged in a rebellion? That's a Daily Beast article, and there's numerous other articles. Furthermore, people have already been acquitted because video footage, exculpatory evidence, was not given to courts of them being peacefully let into the building. Again, that was a terrible day, but we had that terrible day every single day that summer. And the Colorado State Supreme Court isn't banning every single person arrested that summer for engaging in a rebellion. So, I mean, I'm not equating the underlying reasons for demonstrations between that summer and January. What I am saying is that chaos and mayhem is never good, whether it's in January after Trump's speech or whether it's an entire summer with billions in property damage. Because left-leaning demonstrators, a small percentage, decided to engage in billions in property damage and lives lost. CNN said fiery but mostly peaceful. There was literally a building set ablaze behind the CNN reporter, and the person said fiery but mostly peaceful. There was a concerted effort to make that one day in January the most chaotic and, destructive moment in American history, while completely ignoring media and Democrats and others, completely ignoring the rampant daily chaos, the curfews, the property damage. I saw buildings with signs saying, "We support you, please don't destroy the building." And where were all these channels, these million sub channels? Where were they? Where's the footage of the 1 million to 4 million sub left-leaning channels demonstrating that summer? I haven't seen any. Want to know why? Very likely because they were afraid to. Very likely because they knew a peaceful demonstration would devolve into chaos and mayhem, or what the Colorado Supreme Court would view as a rebellion. Hit subscribe if you're new to this channel right now.
In 55 years, I think the other side would say the reason for that is Chief Justice Chase's opinion in 1869 in Griffin's case to start.
Attention retirees.
Congress has the authority here, not the states. That's followed up by the Enforcement Act of 1870, in which Congress acts upon that understanding, which is followed, and there's no history contrary in that period, as Justice Thomas pointed out. There's no history contrary in all the years leading up to this of states exercising such authority. I think the reason it's been dormant is because there's been a settled understanding that Chief Justice Chase, even
Oh my God. Oh my God. Are you serious? Are you serious? I had Mahomes on my fantasy team this year. I love Patrick Mahomes, even though I like the Raiders. But I like the silver and black, and I'm tired of the Chiefs. But my God Almighty. My God Almighty. That, you know what? It's like when you get that INT, maybe maybe you should run. I mean, you know, why didn't he just call a run? This was in the third or fourth quarter. No, fourth quarter. It was the third quarter. I was watching the game on and off. And could you not call a run? This is the same type of thing that happened to the Falcons. I mean, not nearly. It's night and day. I'm just saying there was that one moment. And I'll go back. There was that one moment. It was an interception. The Niners had an interception. And two pass plays, and Purdy runs for it on third down. But it was two consecutive short passes. Couldn't you have just run it? You run the clock out. You could have gotten 40 seconds off or a minute and something. I don't get it. I wanted the Niners. I mean, I didn't really care. And congratulations to Chiefs fans. I mean, I think that Patrick Mahomes is one of the greatest quarterbacks ever, even though I like the Raiders. He really is. But we're not talking about the 85 Bears. You know, we're not talking about the 85 Bears here, or the 89 Niners, or the 2000, or the 94 Niners, or the 93 Dallas Cowboys here, or the 79 Steelers. Anyway, let's continue. Congrats to the Chiefs. I can't believe it! Let's continue.
If not right in every detail, was essentially right, and the branches of the government have acted under that settled understanding for 155 years, and Congress can change that. And Congress does have Section 2383, of course, the Insurrection Act criminal statute, but Congress could change it, but they have not in the 155 years in relevant respects for what you want here today, at least.
No, Justice Kavanaugh. The reason why it's been dormant is because by 1876, essentially all former Confederates had received amnesty, and we haven't seen anything like an insurrection since then. I'd like to address your point.
Well,
Can I go to that point?
After the
Justice Alito?
I don't know how much we can infer from the fact that we haven't seen anything like this before, and therefore conclude that we're not going to see something in the future. From the time of the impeachment of President Johnson until the impeachment of President Clinton, more than 100 years later, there were no impeachments of presidents. And in fairly short order over the last couple of decades, we've had 3. So I don't know how much you can infer from that.
Certainly, but if this court affirms, this court can write an opinion that emphasizes how extraordinary insurrection against the Constitution is and how rare that is, because it requires an assault not just on the application of law, but on constitutionally mandated functions themselves, like we saw on January 6th, a coordinated attempt to disrupt a function mandated by the 12th Amendment and essential to constitutional transfer.
Well, let me ask you a question about whether the power that you've described as plenary really is plenary. Suppose that the outcome of an election for president comes down to the vote of a single state, how the electors of the vote of a single state are going to vote. And suppose that candidate A gets a majority of the votes in that state, but the legislature really doesn't like candidate A, thinks candidate A is an insurrectionist, so the legislature then passes a law.
If you're turning eligible that are enrolled,
ordering its electors to vote for the other candidate. Do you think the state has that power?
I think there may be principles that come into play in terms of after the people have voted that the state can't change the rules midstream. I'm not sure because I'm not aware of this court addressing it. And certainly, as
well, let's change it so that it's not after the election. It's 3 days before the election, based on the fact that the polls in that state look bad. Can they do it?
I think they probably could under this court's decision in Chafalo, where this court emphasized that for much of American history, state legislatures picked their own electors and assigned their own electors themselves. But of course, that would be much more extraordinary than what we have here, which is simple application of normal state ballot access principles to say that we're only going to put on the ballot an individual who is qualified to assume the office.
Could I ask you again the question that Justice Gorsuch asked, and you
So can you hear me now a little better? Ladies and gentlemen, mic check. A little better? How's the audio now? Ladies and gentlemen, how is the audio right now? Oh, let's continue. Tell me in the
to which you responded by citing the de facto officer doctrine. But suppose we look at that going forward rather than judging the validity of an act committed between the time when a president allegedly engages in an insurrection and the time when the president leaves office. During that interim period, would it be lawful for military commanders and other officers to disobey orders of the president in question?
I'm not sure that anything gives military officers the authority to the legality of the presidency.
Why not? Because you say he's disqualified from the moment it happens. Now, I understand the de facto officer doctrine might be used to prohibit people from seeking judicial remedies for decisions that take place after the date he was disqualified. But if he is in fact disqualified from that moment, why would anybody have to obey a direction from him?
Well, ultimately, there still has to be some kind of procedure in place to adjudicate the disqualification. Certainly, Congress could impeach a sitting president, but that's the only remedy I'm aware of that exists for removal or otherwise negating the authority of a sitting president.
Why? Well, on what theory? Because the Section 3 speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
Correct, but nevertheless,
so it operates. You say that there's no legislation necessary. I thought that was the whole theory of your case, and no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment, self-executing, done. And I would think that a person who would receive a direction from that person, the president, former president, in your view, would be free to act as he or she wishes without regard to that individual.
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is
no de facto. That doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside, okay? I think Justice Alito is asking a very different question, a more pointed one, and more difficult one for you, I understand, but I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
I'm imagining a situation where, for example, a former president was, a president was elected and they were.
So, ladies and gentlemen, let me know if you can hear a little bit better now. You can see that the justices, especially Roberts, and we've gone through the liberal justices, are tearing apart the argument that Trump should be banned. Let me know if the audio is better.
25 and they were ineligible to hold office, but nevertheless they were put into that office.
No, we're talking about Section 3. Please don't change the hypothetical, okay? Please don't change the hypothetical. I know I like doing it too, but please don't do it, okay?
Well, the point I'm trying to make is
he's disqualified from the moment he committed an insurrection, whoever it is, whichever party, that happens. Boom. It happened. What would compel, and I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on. What would compel a lower official to obey an order from that individual?
Because ultimately we have statutes and rules requiring chains of command. The person is in the office, and even if they don't have the authority to hold the office, the only way to get someone out of the office of the presidency is impeachment. And so I think if you interpreted Section 3 in light of other provisions in the Constitution like impeachment, while they hold office, impeachment's the only way to validate that they don't have the ability to hold that office and should be removed.
Mr. Murray, can I just ask you about something Justice Kagan brought up earlier, which is the concern about uniformity and the lack thereof if states are permitted to enforce Section 3 in presidential elections. And I guess I didn't really understand your argument or your response to her about that.
Well, certainly if Congress is concerned about uniformity, they can provide for legislation and they can preempt state legislation.
Yes, but you say that's not necessary.
But it's not necessary. In the absence of federal enforcement legislation, these questions come up to this court in the same way that other federal questions come up to this court, which is that a state adjudicates them. If the state hasn't provided sufficient process to comport with due process, a notice, and opportunity to be heard, one can make those challenges. But assuming, as here, we have a full evidentiary record, an opportunity to present evidence.
No, I understand that we could resolve it so that we have a uniform ultimate ruling on it. I guess my question is why the framers would have designed a system that would...
So you think you know Wix?
disuniformity in this way, where we have elections pending and different states suddenly saying you're eligible, you're not, on the basis of this kind of thing?
Well, what they were concerned most about was ensuring that insurrectionists and rebels don't hold office. And so once one understands the sort of imperative that they had to ensure that oath breakers wouldn't take office, it would be a little bit odd to say that states can't enforce it, that only the federal government can enforce it, and that Congress can essentially rip the heart out of Section 3 by a simple majority just by failing to pass enforcement legislation. Federalism creates redundancy, and here, the fact that states have the ability to enforce it as well, absent federal preemption, provides an additional layer of safeguards around what really Section 3...
Yeah, and I'll ask you about the history when I get a chance again. Thank you.
Thank you, counsel.
Justice Thomas? Justice Alito?
So you can see Justice Jackson was not happy with the Colorado lawyer. Is the sound, sorry, but the sound has been, I don't know what's going on with the sound the past one or two live streams. So let me know. How is it now? How's the sound right now? Is it better? Let me know in the comment section. Is it better? Is it at least better? Let me know if it's better.
Suppose there's a country that proclaims again and again and again that the United States is its biggest enemy, and suppose that the President of the United States, for diplomatic reasons, think that it's in the best interests of the United States to provide funds or release funds so that they can be used by that country. Could a state determine that that person has given aid and comfort to the enemy and therefore keep that person off the ballot?
No, Your Honor. This court has never interpreted the aid and comfort language, which also is present in the treason clause. But commentators have suggested, it's been rarely applied because treason prosecutions are so rare, but commentators have suggested that, first of all, that aid and comfort really only applies in the context of a declared war, or at least an adversarial relationship where there is, in fact, a war between two countries. And second, the intent standard would do a lot of work there, because under Section 3, whatever the underlying conduct is, engaging in insurrection or aid and comfort has to be done with the intent to further the unlawful purpose of the insurrection or to aid the enemies in their pursuit of war against the United States.
Now, let me come back to the question of what we would do if different states had adjudicated the question of whether former President Trump is an insurrectionist using a different record, different rulings on the admissibility of evidence, perhaps different standards of proof, then what would we do?
Ultimately, this court would, first of all, if there were deficiencies in the record, the court could either refuse to hear the case or it could decide on the basis of deficiencies of the record.
Well, would we have to decide what is the appropriate rule of evidence that should be applied in this case? Would we have to decide what is the appropriate standard of proof? Would we give any deference to these findings by state court judges, some of whom may be elected? Would we have to have our own trial?
No, Your Honor. This court takes the evidentiary record as it's given, and here we have an evidentiary record that all the parties agree is sufficient for a decision in this case. And then, as I discussed earlier, there's a possibility of a Bose Corp independent review of the facts. But ultimately, what we have here is an insurrection that was incited in plain sight.
But you're really not answering my question. It's not helpful if you don't do that.
He says it's not helpful if you don't do that. Okay, the Colorado lawyer is having a very tough time with not only the liberal justices, but also the conservative justices. Let me know if you can hear this all right.
Suppose we have two different records, two different bodies of evidence, two different rulings on questions of admissibility, two different standards of proof, two different sets of fact findings by two different judges, or maybe multiple judges in multiple states. Then what do we do?
Well, first, this court would set the legal standard, and then it would decide which view of the record was correct, I think, under that. If this court had two cases,
which view of what record? Which record?
If this court had two cases before it, and both of the records were sufficient insofar as both sides had the opportunity to present their case and the essential facts in the record that everyone agreed was sufficient for decision, then this court would have to look at the evidence presented and decide which holding was correct, and then decide that issue for the country. And certainly here, when there is a complete record, lower courts then will be applying that decision, and I think it's unlikely that any court would say, we're going to reach a different decision than the U.S. Supreme Court did, particularly if the court relies on the facts, the indisputable facts of what President Trump said on video and in his Twitter feed, which is really the essence of our case here.
Well,
They were not indisputable facts. They're in dispute. The man literally said, go peacefully. The man literally said, go peacefully. And people were allowed into the building by law enforcement. And the Federal Bureau of Investigation did not find any effort to overthrow the government. So there was exculpatory evidence withheld in criminal trials, and one or two people, I think two, were already acquitted. How's the sound? Let me know.
You had an expert, let's just take that example, had an expert testify about the meaning of what President Trump said. But do you think it's possible that a different state court would apply Daubert differently and say that this person should not be allowed to express an expert opinion on that question? You think that's beyond the realm of imagination?
Not at all, Your Honor. 2 points on that. Number one, President Trump didn't appeal the admission of that evidence in this case. But number two, the second point is that Professor Simi really, he didn't opine on the meaning of President Trump's words. He opined on the effect that those words had on violent extremists. And the essence of his testimony was built around videotaped statements.
Nobody knows the effect Trump's words had on anyone. You can't prove that Trump's words caused any person to commit a crime. You can't prove Trump's words caused any person to commit a crime. He didn't tell anyone to commit a crime, and he used the word peacefully. He said, if anything, they didn't listen to him. If anything, they didn't listen to Trump.
Statements of President Trump himself encouraging, inciting, and praising political violence.
Well, I'm not taking a position one way or the other about whether the expert's testimony should have been admitted or anything like that, or the meaning of President Trump's words. I'm just trying to get you to grapple with what some people have seen as the consequences of the argument that you're advancing, which is that.
Have you been suffering from the after effects of a car crash? The good news.
And decisions among the states, that different states will disqualify different candidates, but I'm not getting a whole lot of help from you about how this would not be an unmanageable situation.
If this court writes an opinion affirming on the basis of the indisputable facts of what President Trump said on January 6th and in the weeks leading up to it, and his virtual confession on Twitter after the fact, then it would be reversible error for any other state to conclude otherwise on that question of federal law, or at the very least this court could address that when those issues come up, but it seems unlikely.
Justice Sotomayor?
There's two sides to the other side's position. The first is that it's not self-executing. I want to put that aside. Deal with if we were to hold that states don't have the right to enforce or create a cause of action in this situation. They want the flip to say that no, but even Congress can't do it because they need implementing legislation. Address that argument. Because assume we rule that states don't have it, what would you have us say for the other side of the argument? One of my colleagues says you need, or not then Chief Justice, but Circuit Court Justice Chase said, which is that somehow you need implementing legislation, like the 1870 Act. You seem to say that's not true because they could decide not to seat a candidate, etc. So I don't know that legislation is necessary.
And certainly there are historical examples of members of Congress under Congress's Article 1 power to judge the qualifications of its members, of members of Congress refusing to seat ineligible candidates under Section 3 who have won election. In the context of the presidency, I think it would create a number of really difficult issues if the court says there's no procedure for determining President Trump's eligibility until after the election. And then what happens when members of Congress on January 6th
There is a procedure. You can convict him. You can't just assume, you can't just feel that he committed a rebellion. You have to convict him of an organized plot to overthrow the government. If Colorado can't convict Trump, or if the federal government can't convict Trump of a plot to overthrow the government, why on earth would any state be given the right to prevent him from being in office or being a president for the second time? Hit subscribe if you're new to the channel. I hopefully have fixed the audio issues.
When they count the electoral votes, say we're not going to count electoral votes cast for President Trump because he's disqualified under Section 3 under the Electoral Count Reform Act. A number of the amicus briefs, such as those of Professor Ginsburg, Hassan, and Foley, have made the point that that is kind of a disenfranchisement and constitutional crisis in the making, and is all the more reason to address those issues now in a judicial process on a full evidentiary record so that everybody can have certainty on those issues before they go to the polls.
Justice Kagan?
Mr. Murray, you relied on the state's extensive powers under the Electors Clause. You talked about the states having a role in enacting, typical ballot access provisions. I guess, it strikes me that we've put some limits on that, and I'll just give you Anderson versus Celebrezzi as an example of that, where we said, in fact, states are limited in who they can take off a ballot. And that was a case about minor party candidates. But the reason was that one state's decision to take a candidate off the ballot affects everybody else's rights. And we talked about the pervasive national interest in the selection of candidates for national office. We talked about how an individual state's decision would have an impact beyond its own borders. So if that goes for minor political party candidates, why doesn't it go a fortiori for the situation in this case?
Well, certainly constitutional principles like Section 3 apply to everybody, but in Calabresi, the issue there was a First Amendment question. And certainly there's no doubt that states' exercise of their power under Article 2 is constrained by First Amendment principles. And in that case, the state law deadlines for when a minor party candidate got on the ballot just came too soon to be reactive to what major parties had done and therefore risk disenfranchising people who were disillusioned with who the major parties had picked. And it raised First Amendment problems. Here, there's no real First Amendment problem, and a state is just trying to enforce an existing qualification that's baked into our constitutional fabric.
Yeah, I guess, it did come up in the First Amendment, but there's a broader principle there, and it's a broader principle about who has power over certain things in our federal system. And, within our federal system, states have great power over many different areas, but that there's some broader principle about that there are certain national questions where states are not the repository of authority. And I took a lot, First Amendment, not First Amendment, a lot of Anderson's reasoning is really about that. Like, what's a state doing deciding who gets to, who other citizens get to vote for president?
Justice Kagan is one of the 3 liberals on the Supreme Court. This is huge, ladies and gentlemen. This will be a 9-0 decision, a 9-0 verdict. This will be a monumental, historic moment. This will be one of the major turning points in U.S. history. Democrats will have had a 9-0 decision completely dismantling their fantasy that Trump committed a rebellion, which of course he didn't.
Colorado is not deciding who other states get to vote for president. It's deciding how to assign its own electors under its Article 2 power. And the Constitution grants them that broad power.
Well, but the effect of that is obvious, yes?
No, Your Honor, because different states can have different procedures. Some states may allow insurrectionists to be on the ballot. They may say, we're not looking past the papers. We're not going to look into federal constitutional questions. It's the sort of, even in this election cycle, there are candidates who are on the ballot in some states, even though they're not natural-born citizens, and off the ballot in other states. And that's just a function of states' power to enforce, to preserve their own electors and avoid disenfranchisement of their own citizens.
Thank you.
Justice Gorsuch?
Haven't had a chance to talk about the officer point, and I just want to give you an opportunity to do that. Mr. Mitchell makes the argument that, particularly in the commissions clause, for example, all officers are to be commissioned by the president. Seems to be all-encompassing, that language. And I'm curious your response to that. And along the way, if you would, I poked a little bit at the difference between office and officer in the earlier discussion, you may recall. But I think one point your friends on the other side would make is, well, that's just how the Constitution uses those terms. So, for example, we know that the President pro tem of the Senate and the Speaker of the House are officers of the United States because the Constitution says they are. But we also know that they don't hold an office under the United States because of the incompatibility clause that says they can't. So maybe the Constitution to us today, to a lay reader, might look a little odd in distinguishing between office and officer, not prepositions, nouns, but distinction. But maybe that's exactly how it works. Thoughts?
Well, I'd start with the idea that the meaning of officer in the 1780s was the same meaning that it has today, which is a person who holds an office. And certainly in particular contexts, like the commissions clause, it appears that that's referring, that is referring to a narrower class of officers, because we know that there are...
Except it says all.
Well, we know that there are classes of officers, like the President pro tem, who don't get their commissions from the President.
Well, that's because the Constitution elsewhere says that.
We know that the Appointments Clause refers to a class of officers who get their appointment from the Constitution itself, rather than from presidential appointment. People who get their commissions from the President himself are not commissioned by the President. And so if you read the Appointments Clause in line with the Commissions Clause, then the commission's clause is really talking about the president's power. If one needs a commission, it's the president who grants it. But I think it's important to bring us back to Section 3 in particular, because that was 80 years.
Before we get to that, though, just the distinction between office and officer, do you agree that the Constitution does make that distinction, particularly with respect to the Speaker and President pro tem?
The Constitution makes that distinction, but at least in Section 3, an officer of the United States is a person who swears an oath and holds an office. Now, the President pro tem and the Speaker of the House, they don't swear a constitutional oath in that capacity. They swear a constitutional oath if they are a senator or representative in Congress in that separate non-official capacity. But I think that
You agree they are officers who don't hold an office?
They're officers who may hold an office but don't swear an oath under Article 6 in that official capacity.
Well, how can they hold an office under the incompatibility clause? It says they can't.
Well, I think that's a fair point, and I think that may be an exception to the general rule, and one might consider them perhaps officers of the House and Senate.
The lawyer for Trump, his argument, or Trump's argument, is that he's not just an officer, he's the commander-in-chief. The 14th Amendment was not meant for presidential contests. It was not meant for any state to prevent a future commander-in-chief. And if one historical note that Alan Dershowitz brought up, why would radical Republicans allow a southern state that power to prevent an entire election from going to one candidate, or a candidate that might be a Republican and not a Democrat, or a radical Republican? They wouldn't have allowed one state at that time period. The point is, they wouldn't have allowed one state that time period to have that much power to decide a federal contest.
Because they are appointed by those bodies and preside over those bodies.
Well, the Constitution says they're officers of the United States. So there are some instances when you have an officer, but not an office.
Those may be an exceptional circumstance, but I would...
Thank you.
You're welcome.
Justice Kavanaugh?
The concerns of some question have been the states having such power over a national office. Other questions about the different states having different standards of proof. And they seem underscored by this case, at least the dissenting opinion below. Justice Sommore said, I've been involved, quote, I've been involved in the justice system for 33 years now, and what took place here doesn't resemble anything I've seen in a courtroom, end quote. And then added, quote, what transpired in this litigation fell woefully short of what due process demands, end quote.
Kevin, thank you again for the super chat. Paul Bartlett, as always, thank you. Thank you both, Kevin and Paul. Justice Kavanaugh is talking about how one of the Colorado Supreme Court justices said that the process was completely flawed and that they should never have allowed, the process was flawed, and that it was a big problem how they came, it was virtually unconstitutional how they came up with banning Trump. And then we can go, I mean, I can continue with this, but the Colorado lawyer says, well, Trump had, every right to do this and that and this and that. And he tries to circumvent the argument. Ladies and gentlemen, be here tomorrow. We're going to have a live stream at around 4 p.m. Eastern time. So be here for the live stream at 4 p.m. Eastern tomorrow. Sorry about the audio issues. I will try to completely fix them. But ladies and gentlemen, thank you. To my super chat, thank you. And hit subscribe if you're new to this channel. Definitely check out the segment prior, the live stream about Nikki Haley. She'll drop out after South Carolina, almost certainly, and then endorse Trump. Thank you so very much, everybody. Hit subscribe, share this, and please go ahead, if you're new to the channel, subscribe right now. I'll be back.